Having said so about the copyright law and its emerging play, I'll just switch over to the patent. Now, the question is the patent law is a monopoly or patent is a kind of a right used for a limited purpose for a limited duration, and the patent law is meant for the greater common good, or the patent is something a patent lies, or patent is something like a latent danger that we have to look into with very probing eyes and try to map out the Indian patent law and the comparative patent law in a wider perspective and try to contextualize the Indian patent law into the political economy of India in the wake of liberalization, privatization, and globalization. We have certain kind of inherent incongruencies of the patent, especially the pharma industry and the pharmaceutical industry in this country, simply because that India appears to be the third largest consumer of the pharma product in the world, and therefore that there is a tendency that most of the pharmaceutical companies are throwing to coming and camping in the India to have their fortunes because the disease and squalor are so rampant in this country that they have a good business. And because of that, certain patenting issues of the pharmaceutical industry has been one of the most uh, litigated areas of. But the Indian Supreme Court and the Indian court have taken again the same kind of the wave which is unleashed by in photo Rameshwari photocopying case by the Delhi High Court and the Supreme Court. We have a Novartis judgment of the Supreme Court in 2013. Of course, we have a Novartis judgment of the Madras High Court as well. But if you follow the decision of the Madras High Court judgment on Novartis and the Supreme Court, the difference appears to be that the Novartis went to the Supreme Court under their special leave petition, saying that if this court will not hear this case, then there will be serious miscarriage of justice, and it is the Supreme Court has to set at rest the entire controversy relating to Article 27 of the TIPS Agreement and as well as Section 3D of the Patent Amendment Act of 2005 and Section DA. The Section 3 of the patent, as we know, that once we say patent, then it should be non-obvious. It should be it was inventive process. It must be capable of industrial application. Having satisfied these three ingredients, we are validly qualified to have our patent to be sealed and granted. And in the same manner, what we see that the legal efficacy, enhanced efficacy, and the issues of issues the enable efficacy, enhanced efficacy, and the issues of evergreening of the patent has been a major concern. And when we look at and we peruse the case of the Novartis, the Indian Supreme Court has taken a very broad and liberal perspective of the third world perspective on the patent law. Uh, in patent law, as we generally see as patent as a talismanic cure, and when we talk of patent, we also talk that the patent filing and the economic development have a direct relationship. But there are certain studies in the world wherein we have deciphered that it is not necessary that when you have a large patent filing, the country will also witness a kind of an economic development. Simply because of the fact that the patent, the patent filing and the economic development is sometimes direct relationship and sometimes having a inverse relationship, because India has a large number of patent filing now, but there are few takers for their commercial exploitations. And therefore, if we analyze the nature, the content, the ambit, and the scope of the patent right in this country under the Indian Patent Act and its amendment in 1999 and 2002 and 2005, then we can validly conclude to this proposition that the freedom to operate analysis, the FTO analysis of the Indian patent law is not something very encouraging, that even you have patent, that the freedom and the liberation aspect of that patent is not something going to have a very long and very ending with a happy note.